So hopefully you can all see that. Adele will let me know if you can't, I'm sure. But thanks very much for joining. Really good to be. You can, brilliant. Really good to be with you this afternoon for, I think this is the second immigration update I've done with you. Unsurprising at the moment, there's obviously lots of stuff going on the immigration front, lots of change happening. So I hope you find the next hour or so really useful as we look at the changes that have really happened in the first sort of 5-6 months of this year, really. So what are we going to do? There are my details. If you would like to link in with me, that would be great. You probably don't need the QR code. I'm sure you can find me if you'd like to, but it'd be great to link in. So what are we going to do? I thought we'd spend a chunk of time looking at right to work check issues. I know that's been a really tricky, fiddly area. There have been quite a few changes in recent weeks. So I'll be looking at that and some of the kind of practical points that you need to be working through there. I'll spend a bit of time doing a skilled worker update, so looking at some of the changes that have affected the skilled worker visa route. That's obviously the visa that replaced the old Tier 2 general visa that we used to have up until the beginning of December last year. There've been some changes in the first few months of this year, despite the fact it's still a very young route. I'm then going to touch on some of the other changes that have happened, some of the new routes that have cropped up. So some of you might have picked up there's a new graduate route that's opening up from July this year, which is going to have a really significant impact, I think, for employers, probably in a good way. Generally, I look at the frontier worker permit, which is another route that I've had lots of questions on. And I'll sort of round up at the end with a few other thoughts on changes and bits and pieces on the horizon. We'll probably try and sort of stop for questions at various stages. So for example, we'll do some stuff on right to work checks and then have some questions after that before we move on. So do raise those, as Adele was saying earlier on, and we'll try and pick them up as we go through. Okay, so should we dive straight into the right to work checks and all of the issues around that? I thought the first thing that I'd just try and cover off is this issue that lots of people have had questions on about the checks that you do on EU nationals who are starting work with you in the first 6 months of this year, so up until the end of June this year, and some of the tricky issues that come out of that. So I think it's really helpful to have a bit of context for why we've got the setup that we've got at the moment. If you think about it, there are different statuses that people could have as EU nationals in the UK, depending on when they came into the UK. So to talk you through some examples, you could have somebody who came into the UK before Brexit, so by the end of last year, has applied under the EU settlement scheme, which of course is the scheme they have to apply under to get their status to stay in the UK, and I've had that application approved and they've got status under the settlement scheme. That's kind of group one, if you like. Group two would be people who who came into the UK before Brexit, so by the end of last year, haven't yet applied under the EU settlement scheme because they don't have to do so until the deadline of the 30th of June this year. But they're entitled to status under the settlement scheme, they're entitled to be here. Or the third group would be people who have come into the UK from the 1st of January this year, so they don't qualify for status under the settlement scheme, and they would need some other immigration permission, for example, a skilled worker visa, being the most obvious visa route. So you've got these different groups of people, and what the government's essentially decided is that it's just too complicated to expect employers to have to unpick that and try and bottom out what the underlying status of a person is. And that's why they've said to employers, as you would have seen in the right to work guidance, all you have to be doing for the first 6 months of this year, so until the end of June this year, is just checking documents essentially in the same way that you've always done, which is that if an EU national shows you their EU passport, that is sufficient for your right to work check. You don't have to sort of drill beneath that to work out, but have they applied under the settlement scheme? Should they have done? Do they need a skilled worker visa? All those sorts of things. That check alone will be enough for you. So if it turned out that you employed somebody and you checked their EU passport and it turns out further down the line that they didn't have the right to work in the UK because they should have applied under the settlement scheme and hadn't done so, for example, you wouldn't be liable for that. As an employer, you would have a defence to what they call a civil penalty for that issue. So that's why we've got it. That's why we've got no change for the first 6 months of this year. Having said all that, I think the right thing to do is still to have conversations that are sensible, pragmatic, open with new joiners up until the end of June this year, just to discuss with them what their status is and what you can do to help them. So I would be discussing with a new joiner, look, are you covered by the settlement scheme? I'm going to apply. Have you already got status? Or do you think you need a skilled worker visa? Because if so, we're obviously going to have to work with you to check out the eligibility, to sponsor you for it, and so forth. So I think having that pragmatic conversation is still a sensible thing to do as part of the recruitment process, because it's in everyone's interest in the end that obviously the person does what they need to do to be in the UK and they've got an appropriate status to live and work here. Otherwise, it will unravel further down the line. You may not be liable for it for the reasons I said, but you might lose the employee. They're going to have a problem. That's not in anyone's interests. Clearly, if a person comes to you and says, I don't want to discuss that, here's my EU passport, I'm entitled to start work, get on with it, that's fine. You should proceed on that basis. You can't force them to give you more information. You can't discriminate against them. But trying to have that pragmatic, sensible conversation is still the right thing to do, I think. A few other points related to this. Lots of questions I've had are around, well, do we have to do checks on our existing EU staff to check they have applied under the settlement scheme? So if they started and we've done the appropriate check when they started, the EU passport, let's say up until the end of June this year, do you have to then retrospectively do a check to make sure that they have applied under the EU settlement scheme? Answer to that, at least at the moment, is no. The government's been clear you don't have to do that. That's not something that is required of employers. And going back to what I said a moment ago, you shouldn't be liable for that if it turned out a person didn't have the right to work, they hadn't done what they needed to do. If it comes to your attention that somebody does not have the right to work in the UK, you should follow that up. You can't just sit on it and say, well, I did the appropriate check before employment started, everything's fine. You should follow up on that, because not to do so potentially invalidates that check that you've done. But you'll appreciate that following up on information that comes to your attention is different to having to ask employers to provide you with information, and they're two different things. So you don't have to be doing those retrospective checks, which is obviously good news at the moment. And finally, from the 1st of July, we will obviously have a new regime for right to work checks. Clearly, the EU passport as a document will no longer suffice for EU nationals. We don't yet have the updated guidance on that. Knowing the Home Office, it will probably land in late June, very helpfully for all of us. But we can predict, can't we, what it will be. It will be somebody will need to show they've got status under the settlement scheme, so that online check that you do for that, or they provide you with another document showing their right to work in the UK, they've got another visa of some kind. The fact that they can show that they're an EU national will no longer be adequate for right to work purposes. So in a nutshell, no fretting, I think, over new joiners for the first 6 months of this year. An EU passport will do. Try and have a pragmatic conversation to minimise the risk of problems arising, and you don't have to do retrospective checks. The second area around right to work checks that I wanted to touch on is the changes that have happened around doing checks during the COVID period. So as I'm sure most of you will know, the government's recognised that doing a face-to-face check with people when everyone's working remotely, got problems travelling and so forth, doesn't really make sense. So we've had this system in place, haven't we, called an adjusted check regime, whereby you can do right to work checks on a person by checking them over a screen and just seeing copies of the documents. So you don't have to be seeing them in person or having originals of the documents in front of you. So all very common sense and good. You will have picked up, I'm sure most of you, that the government originally announced that they were removing that adjusted check regime from the 17th of May, and you go back to the old system of having to do face-to-face checks. They've now very recently, as of the end of last week, extended that to the 21st of June. So up until the 20th of June, you can carry on doing these adjusted checks over screens in the way that you're doing at the moment. And then from the 21st of June onwards, that's when the kind of old rules, if you like, will kick in. Good news is you don't have to do retrospective face-to-face checks. So again, some of you might remember that originally the government was saying, once we end the adjusted check regime, we're going to give you 8 weeks to do a real face-to-face check on everyone that you've done that adjusted screen check for. Good news is that they've abolished that, and they said you don't have to do those retrospective checks. The checks that you did at the time the adjusted check will suffice. That is good enough. Obvious questions that come out of that are, well, what will be the options from the 21st of June, assuming we do end up with a reversion to the usual rules? I thought it was worth just reminding you really of the different ways in which you can do the right to work document checks, because some people, I think, don't always pick up on these different ways. I mean, the first way is the online check portal, which is available for people who've got status under the EU settlement scheme, or they've got a biometric residence permit, so one of those credit card style visa documents. People in those two categories can give you an employer share code. You can go on the online portal and do the check that way. That's obviously a nice, easy, low risk way of doing it. Or you've got the face-to-face check, so you see the person in the flesh, you see their hard copy documents, their passport, let's say, or their visa document in the flesh. That'll be option 2. Or there is a third way, which is you can have the hard copy documents in your hand with the employee on a screen. So you have to have the original documents, but the employee can be on a screen. That's obviously different to what happens at the moment, which is you can have copies of the documents with the employee on a screen. You've always been able to do that hard copy documents in your hand and the employee on a screen approach. It's obviously not very popular because nobody likes sending their passports or visa documents in the post and so forth, but that is an option that you can pursue if you want to do so. Or I suppose finally, you've got a risk-based assessed approach, haven't you, where you could decide, well, we're not going to do a proper right to work check, we're just going to do copies because doing the full checks is just too complicated in some cases. I don't think we can say that's recommended. That obviously leaves you exposed to potential risks around illegal working, and if you're a sponsor under the points-based system as well, that could endanger your sponsor license. So I think really you have to go with one of those 3 options, the online, the face-to-face, or the hard copy with the employee on a screen. You've got to do one of those options, I think, from the 21st of June onwards. Final question I've had around this, at least in respect of the May changes, so I assume this will be the same from the 21st of June, is the question around, well, is the change in terms of the date when the check was done or the start date of employment? In other words, if, let's say, you'd done a check for somebody on the 19th of June, an adjusted check, but they don't start work till the 22nd of June, so obviously the changeover happens between, what rules apply there. I've seen an email from the Home Office which says that what matters, that this was at least in respect of what they were intending to do in May, what matters is the date of the check. In other words, if you've done an adjusted check before the 21st of June, the person starts work on or after the 21st of June, the adjusted check, the screen check, should be good enough. It's the date of the check that matters. I would always say, obviously, we need to watch this space. A month or so from now, things could well change, but that's the position as we currently understand it. And the final sort of point I thought I'd mention only briefly before perhaps we just pause for any questions around these sorts of issues is around not forgetting that Brexit is, of course, a two-way street, as many British nationals are finding out to their cost, and not to forget that when British nationals that you have working for you travel into the EU, just to have on your radar, okay, what are the visa issues we have to be thinking going that way. It's not something that, strictly speaking, I can advise on because it relates to obviously the rules of a different country. In a nutshell, that there is provision for visa-free travel for up to 90 days in aggregate in any 180-day period across the Schengen countries, which is essentially most European countries. Only a very small number, I think Bulgaria, Romania, possibly, and Cyprus, I think, are excluded from that group. So there's flexibility there, but that's really for what you term sort of shorter term incidental activities. I think once you stray into somebody doing longer term, more substantive work in another country, that's where you would need to be, I think, bottoming out, well, what are the immigration rules in that country? Do you need to get a bit of advice in that country? And making sure that you've bottom those issues out to minimize problems for yourself potentially as an employer, but also for the individual. British nationals who are travelling visa-free on that sort of short-term basis, they need to have a passport less than 10 years old. They've got to have at least 6 months validity left on it. And don't forget things like checking out that people have got their travel insurance sorted, their health insurance, because you can't get a new EHIC card anymore. That regime has fallen away. If they're taking their pet, making sure they've got their pet passport, all these kinds of things. A lot of the kind of reciprocal stuff that we had pre-Brexit is not necessarily as straightforward, as simple as it was. So I think that there's certainly a practical point around guidance for staff here. I think flagging for existing EU staff who need to apply under the EU settlement scheme by the deadline of the end of June this year, flagging to British nationals who are potentially travelling overseas just to be aware of these issues, at least perhaps pointing them in the direction of the government gov.uk guidance that's published, and certainly for longer term business trips, working out, okay, what do we need to do to be bottoming those issues out and ensuring that everything is in order. I wonder if there are any questions, Adele, out of any of those issues before we move on to the next section.
Yeah, we have got some questions that have been sort of raised, so I'll just open them up. So one of the questions is, should we keep a copy of the government guidance at different stages as it changes, or will the Home Office be aware of the regulations at the time? So, i.e., if there's an audit in a few years' time, would it be useful to keep what the guidance was at that point?
Yeah, that's a very good question. So I've advised quite a lot of clients. I think it is sensible to print and retain a contemporaneous copy of the guidance that applied at that time with the URL from the internet on it, because obviously what we've not got is it's not been published in a proper, employer right to work check booklet. So I think it is sensible to do that. I mean, in theory, you shouldn't need to do so. But I think the point's made is a good one, which in 3, 4, 5 years' time, in the event of an audit, COVID may well be, hopefully, a distant memory. And so I think, doing that and having it on file, although not essential or a requirement, is probably a sensible, practical step to take.
Okay, thank you. Another question, for those who have pre-settled status, do we need to check they have settled status when the pre-settled expires in the future?
Yes, so somebody who's got pre-settled status has effectively got limited leave to remain in the UK, so they will have an expiry date of their status, and you should be diarising to do a follow-up right to work check on those people in the same way that you would with anybody else who had a visa and limited leave to remain in the UK. You'd normally do a follow-up check, wouldn't you, typically in the sort of the run-up 3 months to the expiry date. And obviously that person should be making sure they apply for settled status if they're eligible to do so. So yes, they should be.
Okay. Another question, can expired passports be accepted for right to work checks?
No, in short, they can't. So if a stamp is in so typically this crops up with people who've got indefinite leave to remain. If you've got a passport with an indefinite leave to remain stamp in it, and the passport is expired, that is not a valid document for a right to work check. It would not give you a statutory excuse to a civil penalty. In practice, obviously the risks of the person not having the right to work in the UK are low. They've got indefinite leave to remain. It's not easy to lose that, but effectively what the government's doing is using the right to work check regime as a way of forcing people to update their documents. So the person should really be applying for an updated biometric document. I think they have to make application, I think it's called NTL, I think, from memory. Costs about £800, I think, from memory, to do that, to get an updated document. The expired passport won't give you that excuse, so you shouldn't rely on
it. So another question, how long do we have to retain copy documents for?
How long do you have to retain copy documents for? Well, if you're a sponsor, the obligation under the points-based system, the obligation is to retain them, I think I'm right in saying, 1 year from the end of sponsorship, or if a immigration officer has seen them as part of an audit, whichever is later. So typically that's going to be 1 year from the ending of employment. But in practice, there may be other reasons why you keep employee documentation on file. There are lots of reasons related to claims that could be brought in some cases within a 6-year window of employment ending. So there are lots of reasons why you keep documents for longer than that. So you'd have to sort of assess what to do on a case-by-case basis on that.
Alex, I have a question. It's Rebecca here.
Yeah.
If somebody has settled status up to the end of June and their right to remain expires, can the company dismiss the employee without the risk of discriminatory or unfair dismissal claims?
Well, if a person, I mean, it's always difficult to advise in sort of generic terms on a dismissal. I mean, if a person doesn't have the right to work in the UK or is unable to evidence it in a manner required by the regime that you're subject to as an employer, then potentially you are in territory, yes, where you would be looking to terminate employment. You clearly can't, you shouldn't be employing somebody who doesn't have the right to work or is unable to evidence that if the regime requires them to do so. I mean, the fly in the ointment there is with an existing employee, the issues can become quite complicated and you have to balance immigration law considerations with employment law considerations. And in some cases, it may be appropriate to, allow a period of time for the person to get updated documents. You'd certainly want to be doing a process to investigate the facts, invite them to a meeting before you make a decision and give the right of appeal, all those sorts of things. I mean, in short, if you end up in a situation where a person does not appear to have the right to work in the UK and they're an existing employee, or you're coming around to an updated check that's required and they can't evidence it, I would say, I'm not just saying this as a lawyer, I think before dismissing that is a situation where getting some legal advice is sensible, because the issues can get a bit complicated.
Wonderful, thank you. Back over to you, Adele.
Oh, thank you. Another question which several people have asked this one is, what proof do employers require for settlement status? And can this be used? And it's the link to the gov.uk view right to work to establish an employee's right to work rather than getting original docs and verifying it.
Well, so the online check is available for people that have got status under the EU settlement scheme or got a biometric residence permit. And what they need to do, what the employee or prospective employee needs to do, is give you the code that they have to obtain, the employer code that enables you to access the system, look up their details, print them off, and it leaves a digital footprint. So that is only an option for EU settlement scheme where people have got a biometric residence permit and they need to give you the code to be able to do that. So if somebody's in that situation, talk to them about it. If they can't do that, then you're down to the other ways, which would include obviously the hard copy documents, most obviously. So does that answer the question?
Yeah, I think you did cover it in your presentation.
Yeah,
I'm not sure when the question was raised. So yeah. And then just sort of the last one is, how do you conduct a compliant right to work check for home workers? It's difficult to see original documents due to geography, and the UK guidance is not clear.
Well, that comes back really to what I was saying, which is, I think the guidance is clear. So at the moment, there is an adjusted check regime in place, which means that for checks done up to and including the 20th of June, you can be sent copies of the documents, which you can then view in front of you with the employee on the screen over a Zoom call, a Teams call, and do the check that way. And you have to write on the copies that you have seen the wording that's on the gov.uk website. I can't remember exactly precise wording, something like this is an adjusted check, done on this date, something along those sorts of lines, and then retain those copies on the file. That is the regime up until the 20th of June. It's specifically been designed so you don't have to do the face-to-face checks. And then it will change from the 21st of June onto the usual options as set out below in the middle of that slide.
Yeah, okay, thank you, that's great. Should we move on to the next section?
Yeah, perfect, okay, brilliant. So I wanted to do a bit of an update on the skilled worker visa category. I mean, just to remind you, some of you may well have joined some of the webinars that we run more generally, or indeed we covered some of this in the last session that we did for CIPD. So I'm not going to cover it in huge detail in terms of a recap, but this is, by way of reminder, the replacement to the old Tier 2 visa. That's a sponsored visa route for a worker who's got a specific job offer with you, they've got to get that 70 points to qualify, mix of mandatory points and tradable points. You can earn the tradable ones through combination of salary or qualification or personal characteristics. The minimum skill level to qualify came down hugely from level 6 down to level 3. So essentially any deemed A-level skill level roles are now in scope for sponsorships. That brings into play lots of sort of mid-junior level roles across the whole kind of business world, really, that weren't open for sponsorship under the old regime. The advertising test, the resident labour market test, to try and show you can't recruit a settled worker, that's all gone out of the window. Still a route that leads to settlement in the UK, and there's no maximum time that you can spend in the category. So those are kind of the main features that have come into play. And obviously, because of that, it's a more straightforward route. It's a bit more flexible, more people can qualify, and there's some reduced administration. So generally, good news. It's a welcome replacement to the old Tier 2 general visa. But one of the things that had caused some consternation was around the documents that you have to keep from a recruitment process. So I've just said that you don't have to conduct the resident labour market test anymore. In other words, you are not required to have to advertise a role in a prescribed way with a job advert that contains certain information for a minimum of 28 days in certain locations. All of that has gone out of the window. But over the course of this year, there've been various iterations of the guidance still suggesting that employers would still have to retain paperwork from an advertising process, even though you're not required to do an advertising process. Employers were quite rightly saying, what on earth's going on? This is a nightmare to navigate. What do we do? We've now got a reasonable degree of clarity on that with some updated, what they call Appendix D, which is the sort of checklist guidance that you have to follow for the documents that you should keep for each person that you sponsor. And I put pretty full slides together here, just so you've got an overview of the documentation. If the role was advertised, so you don't have to advertise, but if it was advertised, which in most cases obviously roles will be, you have to retain all of the following. I put it on the slide. So details of any advertisement placed, which could include the screenshot, printout, photocopy, or record of text of an advert. So for example, if for some reason you had lost the advert, you hadn't taken contemporaneous screenshots, it seems that is not a disaster. You just have to keep a record of the text. So just, a physical record of what was included as the text of an advert would, it appears, suffice. You've also got to keep information about where it's advertised, so website address, and for how long it's there. Not that there is a minimum period it has to be advertised for. It could be advertised in theory for 1 day, but you have to keep a record of where it was advertised and for how long. So it seems to me in most cases, most adverts are going to be online, perhaps on our own company websites, university website, or jobs.ac.uk or Monster, whatever it may be, one of these sites. It seems to me the best thing to do is to take a screenshot, which has got the URL website address, and alongside that, you keep a record of how long it was advertised for, and that would kind of meet those first 2 bullet points. Third bullet point is a record of the number of people who applied and the number of people shortlisted for interview or other stages. You don't have to keep copies of the applications. You don't have to keep copies of that paperwork. It's just a record of the number. Simple as that. And I know that many recruitment systems, I think Stonefish, for example, lots of other ones that you'll be using, do automatically keep that information as part of the process anyway. And very often, for wider reasons around evidencing why someone was appointed, to deal with any future discrimination claims that may be raised in relation to recruitment, you would be keeping more information in any event. And then in addition to that, you've got to keep one item of evidence showing how you identified they're the most suitable candidate, i.e. why you appointed them to the role. Non-exhaustive examples of that one item of evidence are there listed on the slide. And again, you'll see actually quite a lot of flexibility there. So a list of common interview questions used for all candidates would suffice. So you don't even have to keep a contemporaneous record of the interview notes, the scores that were given, how that compared with other candidates. The reason for this is the Home Office essentially has a requirement that anybody who's sponsored for a visa should be doing a genuine role. It's a genuine vacancy that's been filled, and the way they're choosing at the moment to evidence that, or asking employers to evidence it was a genuine role, is through this kind of retention of some recruitment paperwork. So in a nutshell, if it's advertised, really a copy of the screenshots, how long they were advertised for, the numbers that applied, and just something from the recruitment process along those sorts of lines would do. You've got a lot more flexibility than you had under the old system. And if you didn't advertise, which you don't have to, remember, you don't have to advertise, you've got to keep some evidence as to why the person you appointed was suitable. And that's, again, going to vary, isn't it, depending on what happened here. If they applied internally for a job, you know, going from one role to another, some sort of note on the file about why they were suitable for the role would suffice, you know, keeping their performance reviews on file, for example. If all else failed, I would say just a note on the file, a dictated note, a typed note as to why they were appointed and why there was no advertising is sensible to do. It's not that you're having to meet some substantive requirement here, it's just that you're having to keep some evidence about why you appointed the particular person. So I think, you know, where does that leave you? I think you've got a lot more flexibility. You shouldn't really ever be in a situation, I think, where you can't appoint somebody. You're always, I think, or should always be able to collate the information that you need to be able to appoint somebody. And a case, I think, of updating your internal checklists if you're a sponsor, and just making sure that you work that through on a case-by-case basis to minimise those risks. Some other things to note on the skilled worker visa. You will recall that there is various requirements around salary. So you have to meet what's called a general salary threshold, a sort of absolute floor in actual earnings that a person must be paid. And they also have to be paid at what's called the going rate, so the published rate in the code for the role that's published online, which may well be higher than the absolute floor. You know, both requirements have to be met. That is also now subject to a minimum hourly rate of £10.10. The reason they've done that is effectively to stop employers employing people for really long weeks as a way of kind of managing to meet the salary requirements. It's to stop artificial inflation of working hours effectively. So, in most cases, you're never going to have a problem meeting that, but I flag it just in case. And there have been some tweaks to the shortage occupation list. So we have a list published of roles where it deems to have a shortage of skilled workers in the UK to do the roles, where essentially people benefit from lower salary thresholds to qualify and some reduced costs around the sponsorship. It's been amended to include some extra roles that I've put on the slide there, mainly in the health sector. So in practice, it doesn't make that much difference to most employers. And actually, most of those roles in the health sector, the salary requirements would have been met anyway without being on the shortage occupation list. So it doesn't make much practical difference. Laboratory technicians are on there. That's a role that might be of interest if you're in the university sector. I know some people here today are from universities. Lab technicians are now on that list. So they benefit from shortage occupation list points, meaning that the salary threshold is lower for them than it would otherwise be. Again, making it more straightforward to recruit people to those sorts of roles. And that's a list that's going to be kept under review. So it will probably be amended. Well, we don't know how long, but I would guess, once or twice a year, perhaps going by the past record. The government said they're intending to be a bit more flexible, try and be more adaptive with the rules to the kind of the needs of the economy, feedback from different sectors. So could it be that it gets updated a bit more frequently than has been the case in the past? Possibly. Bit of a watch this space, but we have already had one update this year on that. And the final thing, which I'm not going to mention in much detail because it's relevant really to universities. I know we've got some universities with us today in this session, but so I'm just going to flag it in headline terms. But essentially, if you are with a university and you're recruiting people to undertake postgraduate research roles, so postdoctoral researchers, academics doing research work, there's a new requirement from the 21st of May that they have to get what's called an ATAS certificate before you can sponsor them. That's a certificate to confirm that they're kind of good to be sponsored, part of our regime to make sure that we don't train up or enable people to do research in this country to develop skills that could be used to create weapons of mass destruction or conventional military technology that is then used overseas, perhaps in less savoury regimes than the UK. So it's effectively going to apply to anybody who's going to take on an academic or research role doing postdoctoral research in certain listed fields. They publish the coded fields, but it's quite broad. It's things like, let me just find my list to give you a bit of a flavour as to how broad it is in terms of the requirements. I want to find this: medicine, biological sciences, vet sciences, physical sciences, maths, engineering, technologies, and so the list goes on. So a lot of areas are going to be covered. So if you're in recruitment in a university, have that on your radar. There are some exemptions for nationals of those countries, but anybody else will need to get one before they can be sponsored. It's usually a 20 working day turnaround, a free online application. So not particularly straightforward. So generally fairly straightforward, but just another sort of administrative hurdle to have to jump over before they can be sponsored. So I wonder, are there any questions on any of what we've covered there around the skilled worker changes, or indeed the category more generally? If anyone's got any questions about that visa route, any difficulties that they've encountered with it, very happy to try and pick those up now.
Yeah, there's a couple come through, Alex.
Brilliant.
So somebody's asked, is there any more information on ATAS on the government website? I know we were waiting for more guidance.
No, there doesn't seem to. I'm always hesitant to say yes or no to those questions, because obviously stuff can get put out rather late in the day. When I last looked, which I must confess was actually at the end of last week, there wasn't anything out yet. My understanding is that the updated guidance has been shared via UCIA with the sector privately before it is being published. So I think if you are in a university, I suspect that through UCIA there will be a way to lay your hands on that guidance, even if it's not yet, which I don't think it has been published online.
Okay, thank you. Another question around being a sponsor. Is there any other documents we should keep on file as sponsors apart from Appendix D?
So Appendix D lists the documents that you are required to keep on each sponsored employee, and the contents of Appendix D go well beyond what we've covered today. So I was just covering what you have to keep in terms of the recruitment paperwork. The list is extensive. So it would include, for example, passport copies, biometric residence permit copies, full absence records of the employee, details of when they entered the UK if it's not apparent from their passport, their pay slips, qualifications that are required for the role, or if they've been sponsored based on tradable points, and so on. It's quite a long list. So if you are sponsoring somebody for a skilled worker visa, you need to look at Appendix D, use that as a checklist to make sure that you've got on file for each person all of those documents that you're required to have. It's quite a long list.
Thank you. Another one, it's probably the last question. From July the 1st, will it become illegal to work online from a foreign country without settlement whilst delivering work in the UK? So this is people being based outside of the UK working for the UK.
Well, I touched towards the end on some points around that. I mean, in short, from an immigration compliance perspective, there's only an issue when the person enters the UK and does stuff in the UK. So somebody can be employed and based abroad, and they don't need a visa or immigration permission to do that. As soon as they enter the UK, that's when, if you like, the immigration rules bite, and you'd have to be bottoming those issues out. There are a whole batch of other issues that can relate to overseas working around tax, social security, pensions, etc. I was going to touch on those briefly at the end, actually, just by way of red flagging some things that I've seen people getting a pickle over recently.
Okay, thank you. Thanks, Alex.
Good. Okay, so we'll go on to a few other changes I wanted to flag that are worth having on your radar, but obviously doing very much an update, so we're not able to go into huge detail on any of this, but hopefully it gives you at least some, as I said, key things that you need to know. The first is this new graduate route that opens from the 1st of July this year. This is a new post-study work route for international students. So essentially, once somebody who's been a Tier 4 or student under the new regime has completed their studies, they can then apply to get this visa, a non-sponsored visa not tied to a particular employer, and to work in the UK. And if they've been an undergrad or a master's, they can work for up to 2 years, PhD for up to 3 years. Really significant change because it massively expands the flexibility for international students to stay in the UK post-study and work, so seen as key to the attractiveness of the UK as a destination for international students. Their family members, if they're already here, can also get this leave, and they can work for any employer that they want to during that period, or be looking for work. They're not subject to salary thresholds or skill thresholds. And then at some point in that 2 or 3 year period, they'd ideally want to be able to get a job with a skilled worker visa that qualifies for that visa. They can then move into that, and that gets them into the kind of track, if you like, to be able to stay in the UK longer term. So really, it's a really good route, and I think it's going to be, you're going to see a lot more of it as employers in the months ahead, because you're going to get more people who will obviously be presenting as new recruits with this leave and saying, well, I can work for you, I don't need to be sponsored. And that's true. Some of the graduate leave will be able to work for you for two or 3 years. So lots of employers are seeing it as a good kind of try before you buy type option. You can employ somebody, see what they're like, in most cases get them through probation or not, as the case may be, before making a decision whether or not to switch them into a skilled worker visa. So, and it's designed, as I say, to enable kind of young graduates to get into the labour market more easily. So I think you're going to see more people coming forward with this kind of leave, and it's good for you because it means that you don't have the costs, the hassle, the administration, the risks of sponsorship for that period, and you only kind of really get into that, if you like, once the person is, you know, kind of a good employee, somebody you want to keep on longer term. So a really good option looking forward. So that's from the 1st of July this year. You're going to start to see people with that sort of leave. And then just to flag what's called the Frontier Worker Permit, which is for people who are EU nationals living overseas in another EU country, but who work in the UK on a regular basis. So these are people who, effectively, this is part of the Brexit exit arrangement. So the UK has agreed to this permit type arrangement to enable people that were doing that pre-Brexit to be able to carry on doing it post-Brexit. The reason I'm sort of flagging it is because lots of employers have got people who might be in a situation where they employ them and they're only working in the UK, you know, a day or two a week, or a week a month, let's say, or they may be looking to employ somebody who was working in the UK last year at various stages and may be eligible to get this permit, enabling them to work looking forward. It's potentially a broader application than first meets the eye. It's designed for those primarily outside the UK, so you've got to be in the UK less than 180 days in a 12-month period. There are certain exceptions to that, and you've got to have been working in the UK at least once every 12 months, and the work should have started by the 31st of December 2020. It's got to be, can't be sort of completely sort of irrelevant or incidental work. It's got to be something relatively substantive that you'd evidence through contract of employment or something like that. But somebody in that situation, they can apply for and get a Frontier Worker Permit to enable them to keep coming into the UK to work looking forward. And that's for a 5-year period. You get a permit. It can be extended beyond 5 years, it appears. There's no fee attached to it. And obviously there's no particular requirements attached to it. You're not tied to a specific employer or a specific job. Why am I flagging it? For people who need Frontier Worker Permits, if you're going to come into the UK from the 1st of July onwards, you'll need to get one from the 1st of July onwards before you can come in. That's point one. So if you've got people doing it, make sure they're aware they must apply for one sooner rather than later, because to enter from the 1st of July, they'll need it. But then secondly, it might be that there are a small number of people who you would otherwise think, okay, we've got to try a skilled worker visa or one of the usual routes, who might, based on their previous work and activities in the UK before Brexit, possibly qualify for this permit, which is, as I say, more favourable for them and for you in terms of costs and hassle and administration. So have it on your radar at the very least. Have conversations with people in that situation to flag it, make sure they're aware. And I don't think there's much to be lost in many cases by making an application. If somebody thinks that they are probably eligible, then due to the way the application system works and the quite light touch way it works, many people might well find that the permit is granted. So it's definitely worth looking at. And then with that, a few other points to mention by way of roundup. We've got the global talent visa that some of you, again, in universities will use, a non-sponsored route, certainly for researchers and leading academics. There's now an option from the 1st of April this year where somebody who's got a prestigious prize can bypass the endorsement process. It might not seem that big, but it does mean that many actually leading academics will effectively automatically be endorsed, saving a lot of time and hassle from that process. At the moment, there's a COVID switching concession in country, so you might be aware that there are a number of rules around who can apply in the UK for a visa in normal times. So for lots of visa categories, somebody has to leave the UK and apply to come back in before they can apply for that particular type of visa. At the moment, there is a switching concession in place, recently confirmed by the Home Office after some ambiguity in the guidance. That means that essentially you can switch from almost any category in the UK into another category, i.e. you can apply in country without having to leave the UK. And at the moment, that also, it seems, includes visitors. So somebody who enters as a visitor, often there'll be a visa, non-visa national, they've not applied for entry clearance, they just come through Heathrow as a sort of holiday maker, as it were. They can apply, for example, in country for a skilled worker visa at the moment because of that switching concession. So that's quite a big change at the moment that will obviously expire at some point linked to the COVID situation. And looking forward on the horizon, there's, I think, to illustrate really, but we've got quite a flexible immigration system now. It's going to gradually be evolving and developing. So we've not had a kind of cliff edge, end of old system, here's new system. Rather, it's kind of a more organic phase developing process. And there's been talk in the recent, well, not so recent budget around more changes on the horizon. So talk about having an unsponsored, highly skilled visa from March 2022. Not clear exactly what that will look like, but another visa route that's certainly for some higher skill, perhaps tech roles, possibly university roles, might well be useful. Talk of a fast track scale up route. So again, designed to enable sort of startup businesses to be able to recruit people more easily. And talk of a new global business mobility route from next spring. So the idea that international businesses that have international operations want to move staff around, a new route, probably replacing the current intra-company transfer route, which is essentially now largely redundant, being introduced. I think there's a recognition really that the current UK immigration system isn't particularly fit for purpose for lots of global businesses, and the reality of how they work and the way they move staff around, that seems to have been recognised, and there's a new route apparently in the pipeline for next spring. Those of you that have the misfortune, as I do, of having to use the sponsor management system and the slightly shambolic way in which it's built and operates, they are road mapping and trialling a new portal at the moment, which they're talking again about rolling out in 2022. Watch this space. It would obviously be great to have something that's a bit more user-friendly than the current system in terms of finding information, making reports, all those things that you have to do in relation to sponsored staff. And I think we're going to continue to see, lots of changes in the months ahead. There's obviously lots of changes around COVID. There's probably going to be more concessions ending as the weeks and months go by. Don't forget all the travel issues as well, the quarantining and so forth that comes into play. So it's a really sort of fluid and interesting / tricky time at the moment. Just before we stop for a few questions, I really wanted just to flag, only in total headline terms, really, the issues to be aware of when you do a staff-based abroad, because you can sometimes be sucked into thinking, oh, it's just about visa and immigration issues. We've certainly been working with lots of employers that have encountered all sorts of problems with people who've sort of tootled off to their home country to work remotely during COVID, and then months later there's an almighty can of worms to have to deal with. The issues there on the slide, things like what are the local labour law requirements? What rights does the employee have in that country? They're often quite strange and not what you'd expect, perhaps around notice periods, working time issues, having to fund certain things, number of instalments of salary, those kinds of things. In some cases, you can trigger risk to corporate tax liability in another country where somebody's working. That can be a nasty. Employment-related taxes, they have to be accounted for properly. The rules vary from country to country. but not doing that can result in the employee being liable in that country and also potentially in the UK. Again, setting up payroll provisions, social security arrangements, pension issues overseas, some of the defined benefit pension schemes that many sectors have. You can't have active membership if you're based working overseas. Data transfers, are your insurance policies fit for purpose, employer liability insurance? Do they cover staff based abroad, for example, as well as the visa issues, both in terms of that country and making sure that if somebody's sponsored for a UK visa and they're going abroad, that you're still able to meet your sponsor obligations, you can report on them, that you're not messing up their ability to get indefinite leave to remain, and so forth. Obviously, a huge amount there. Lots of that is dependent on the country that somebody is in. In fact, all of it is really dependent on the country that the person's working in. But if you've got people in another country overseas working, I would say you need to do some sort of audit around who are they, what country are they in, what role are they doing, and how long have they been there? And then working out, okay, to what extent do we need to get advice on this, try and regularize things, take a commercial view on a situation. The issues can be quite significant. Probably a good moment to stop for any other questions there, Adele, and then I'll sort of pick up a few kind of final action points to round up with.
Okay, so there's been a few questions sort of come in. So one of them is, for the graduate route, can they work at any company and any type of contract? For example, can they work part-time? Yes, that seems to be the case. So it looks to be a route where the person can work or indeed be self-employed or indeed just be looking for work for any employer in any role, no skill level, no salary requirements. So huge flexibility, yes. Thank you. Is there a consultation on the intercompany transfers at the moment? I'm not certain of the answer to that. I think possibly there might be at the moment, possibly connected with this global mobility route that they're looking at for the spring of next year. I'm not certain off the top of my head. Okay, thank you. And then a question about Tier 4 student visas. Yeah. I think the question's around term time dates. Yeah. Would an email be sufficient? So postgraduate students have all year term time, so the dates aren't applicable, as they should be working 20 hours max. Yeah, so what's so if you are an employer looking to employ a student or Tier 4 visa holder, so the old regime was called Tier 4, it's now called student, so you might see people with either visa. If you look in the employer right to work check guidance, there's a section on the extra documents that you have to get from the individual to verify their right to work in the UK due to the limits on term time working. The full details escape me, but it will be some evidence around term dates from the institution. And I think the term dates that apply to that individual, because different term dates apply depending on the course that they're studying. So for example, an undergraduate student will usually be subject to the term times that the university has for, the standard term times. But postgraduate research students do not usually have term times. They're usually treated as being in term time throughout the whole year, so subject to 20 hours per week throughout the whole year, save for a small number of weeks where they're actually granted holiday by the institution, rather like an employer grants an employee leave. So it's a case of looking at the right to work check booklet on exactly the documents that are required. I think it is something around the evidence of the term time, precisely what the format is, whether an email or it's a letter from the institution. I'm not sure off the top of my head. Okay, thank you. There was a question that was raised earlier on as well, and this is like the last question, is if a Hong Kong resident has recently provided their BNO visa, does an employer also need to sponsor that individual? Sorry, say that again. If a Hong Kong resident has recently provided their BNO visa, does an employer also need to sponsor that individual? I don't think so. I think a British national overseas person with that visa would have entitlements to work in the UK. But I'm going to be honest and say, if you phone me up and ask me that, I'd say just give me a couple of minutes to check it. Yeah. Give you a call back. So I'm 90% certain that's the case. But I'd say that I think you need to check that. Okay. Thank you. Apologies. That's it then in terms of questions, Alex. So
great. Well, let me just run up with a few final thoughts then to think about. I mean, what will be some takeaways? I think the first is your sponsor license. So make sure that it covers, if you're a sponsor, all of the things that it needs to cover. Does it cover all of your locations in the UK, your overseas entities, if you've got them? Is it in good order in terms of the annual number of certificates that you've got, undefined certificates that you use for many sponsorships and applications? Just check it's in good shape. Because very often I've seen licenses that aren't quite fit for purpose in the new post-Brexit landscape in the way that they were pre-Brexit. You can apply for extra certificates during the course of the year if you need to do so. So thinking around what's our recruitment likely to be, how many extensions have we got, working out as best you can a rough number and getting ahead of the curve to apply for extra ones is sensible to do, I think. And so think about effective use of visa routes. So the UK landscape's changed quite significantly. We've got, touched on today, a skilled worker visa, the graduate route coming out, the global talent visa. You've still got the temporary worker routes. You've got the visitor routes as well. I think lots of employers are not necessarily as sort of au fait with all of the different routes, quite understandably, as you could be, and how to make effective use of them. So I would say, certainly reviewing policies, procedures, thinking, are we making best use of those routes? Are there other ways that we can get staff in that is less hassle and less cost, is worth doing given the changes that have happened? Properly resourcing, I think your setup, thinking about that, given the numbers that you might have, certainly in the post-COVID landscape as well, when we get back up to normal sort of recruitment patterns, perhaps, have you got enough certificates? Have you got enough resources at your end in terms of managing the sponsorships, paying for the fees, for the costs? Assigning resources to that is key. Don't forget existing EU staff, that 30 June deadline. Good comms to them about the deadline for applying, I think, is really key. And as I say, if you've got staff based abroad, make sure that you do that audit. Where are they? What are they doing? How long have they been there? And work out what sort of advice that you need to minimise those nasty compliance issues cropping up.